Most of us understand wrong from right. At least we understand societal norms for our conduct. We know that punishments exist for doing things that are wrong. Punishments for unethical conduct as an expert witness can include jail time or fines. Less severe ethical breaches can lead to inadmissible testimony or the loss of your reputation, and the loss of future jobs. As a tactic, then, an expert witness must never become an advocate for the side that hires you. Yes, you can help one side or the other, but objectivity has to remain the underlying theme. If the side that hired you represents the proverbial bad guy, then your work may wind up helping the wrong side, at least from an ethical or moral perspective. Your investigations and analyses should help guide the attorneys who hired you toward better legal decisions. Yes, you may feel better about helping the right side, but your investigations and analyses should remain the same when working with either side. Your goal is to determine the pluses and minuses that you learn from your tests or research and inform your retaining attorney. Let him decide the best way to use your findings. Frequently, you will not even know whose side in a case has more merit until you have reviewed the documents and can come to firm opinions about what has happened. Sometimes you'll discover that a defendant has lied to their attorney, and sometimes you may discover that a district attorney has based his prosecution on evidence that a police investigator has misrepresented. In either of these two scenarios, objectively analyzing the technical evidence will enable you to set the attorneys right. In the preliminary phases of the case, your work can help to guide the attorney. Later in the case, your work can help the court to reach a just verdict. You must be aware of these ethical considerations in your dealings with lawyers and the legal system. The more quickly you recognize ethical pressures, the easier it will be to resist them and become a better expert witness. We learn right from wrong at an early age. We learn that murder, hitting, stealing, and lying are wrong. Black and white issues like those are easier to recognize than gray ones, such as not telling the truth when you know it. The conduct of expert witnesses ranges from the blatant to the subtle. You've probably heard about district attorneys or cops who lie to help convict a defendant they believe is guilty. I have seen law enforcement personnel overstate new evidence when defendants have had prior offenses. In those cases, they said the defendants deserved it. But I've also seen expert witnesses testify to facts that they had not personally discovered. I have also watched expert witnesses testify to final opinions without looking at enough evidence. Ethical conduct in the legal arena affects the relationships you have with the attorney and/or the client, and those relationships can subsequently affect your own ethical actions. The expert witness must be an objective contributor to the legal process. You have a responsibility to present technical truths that you discover as an expert. Leave the advocacy to the attorney. Keep the objectivity for yourself. If the other side can show that you are not objective, the judge can disallow your testimony and you will have wasted your work. So you may wonder what ethical questions you should consider, and how will these questions affect your work as an expert witness. First, you should not falsify or overstate your credentials. It's likely that opposing counsel will uncover those lies and cast justifiable doubt on the rest of your testimony. Corporate employers are much more lax in checking credentials on a CV than are well-trained lawyers, Clean up your resume and write the truth. Let your experience lead you to the cases for which you are qualified. You should also not take on a job if it stretches beyond your credentials and competence. Opposing counsel can easily determine when you testify outside the scope of your core expertise. A common result is that the court rejects your status as an expert witness, even though you're an expert, and excludes your testimony. Finally, you should not even consider an expert witness role if you have any conflicts of interest. For example, it is a conflict if you are working on another case for one of the lawyers in this case. It is also a conflict if you have previously discussed details of the case with members of the other side. If you suspect a conflict, discuss it in advance before the attorney hires you. If no problems exist with a case and you take it on, you will shortly recognize what steps should be undertaken as part of a thorough investigation. Once you, as the expert, determine and identify those steps, you have to take them. You cannot skip steps and say that you did them. You cannot have anyone else do the steps for you and then say you did them. You cannot change the results of any of the steps, and you cannot insert falsified data into an otherwise set of valid results. Just do what should be done and to do it honestly. A key tactic then, the judicial system expects you to avoid becoming an advocate for the side that hired you. Objectivity and an ethical approach to your work as an expert witness demand that you do the work first and then draw your conclusions afterwards. Even if your conclusions at the end of your work are the same as your expectations at the beginning, you simply cannot firm up those conclusions before you have a legally defensible basis for drawing them. A cross-examining attorney that discovers that you reached a conclusion first and then justified it and are now testifying to it may easily diminish the strength of your testimony or even have it stricken from the record. You also cannot ignore available and relevant information. Your objectivity must include whatever you discover when working toward your opinions. Otherwise, an attorney can attack your conclusions as false simply because you did not take all known facts into account. You also cannot leave out data that you believe will skew the results away from a conclusion that you want to have. You cannot reverse an opinion expressed in previous publications or testimony just because your new attorney wants you to take this new position. However, if the facts in this case do lead to a different conclusion, you should simply prepare explanations of the discrepancy between this opinion and any one that had been previously expressed. You cannot have a fee schedule that is contingent on a successful outcome in the case. This does establish a bias in your opinions. Using contingent fees is enough to justify the exclusion of your entire testimony.